Welcome to Real Estate Investment Management Brokers Development LLC Legal and Maintenance Interactions. Real Estate Investment Management Brokers Development LLC Narrative for Apartment Manager to Tenants Requested Relationship. Legal, including conversation, texts, emails, phone, FaceTime, mediation, and binding arbitration, avoiding litigation and no litigation, specified tenant response remedies for maintenance events and other apartment management situations. Thank you for being interested in reserving and renting an apartment managed by Real Estate Investment Management Brokerage Development LLC, or REIMBD LLC for short. Apartment maintenance and apartment service interactions between the apartment manager and tenants we serve, and professional boundaries when performing maintenance service work for the apartment. When you need to request help in general, make maintenance requests and service requests, whether text, email, phone, or other forms of communication, please address us as our role and title apartment manager, so we can maintain a professional defined boundary and role as we serve you with your apartment needs. Using this role title to correspond with us represents and reminds all parties that our only interactions involving the tenants is to serve them with their apartment needs, such as service repairs and maintenance repairs of the apartment. If later the tenants want to know the specific person acting as apartment manager for a specific date and time, we keep that on record and it will be provided upon request. So, for example, you might text or email us a request. Apartment manager, this is tenant Jane Doe, cell phone, this, email, this of apartment address 448 Park Drive, number 3 in Boston, Mass. 02215 of bedroom 1. Our kitchen faucet is leaking. When the water is turned on at this place on the faucet, see the picture in a short 15-second video we texted you. And then you might say, I consider this an emergency if the faucet is continually leaking and it won't stop, or it's a non-emergency if the water flows only when it is turned on and there is a limited amount of water. And we will respond by calling the tenant to do some self-help, such as shutting off an emergency water valve, which we have in the apartment, to mitigate the damages, so there's not a lot of water damage. And then we will create a work order and send in a plumber to replace the kitchen faucet or to make whatever repair is necessary. Then we will send the tenant that made the repair request after we do our work and have our worker do his or her work, a survey. Now, this is a very important part of the relationship that is necessary for us. We take our responsibility to make these to perform this service seriously, and you have a claim on us for that, and we embrace that. But we want from you a response and of that the repair was made on this date and this time, that you're satisfied or you're not satisfied. So we might send you a survey response. It said, did you make the repair request on this date at about this time? Did the apartment manager request you shut off the emergency valve? Did this stop the leaking temporarily? Number 3, did a plumber visit at this date and time? Was the plumber a professional? Is there leaking anymore? Does the kitchen faucet now work? And do you consider the matter resolved? And should we close out the case? Number 8, are you satisfied? Yes or no? And do you have any comments? And number 10, how would you rate your service experience? 1 being the worst, 10 being the best. Now, these survey requests is part of our response to making service is very important. It's part of our legal agreement. So if later you want to make a claim, you say, well, 2 years ago, we asked you to do this plumbing repair and you didn't do it. Well, we want records. We're going to have records of the expense in the event, but we also want a response from you as part of those records saying, well, you did make that request and we did come out and do it and you said you were satisfied, so we don't feel there's a claim. Or or it's opened and it's not resolved. So that's why we do that. The rental reservation and package, which includes the rental reservation instructions, lease addendums, disclosures. We are required to provide in substantial legal section, which includes estoppels, conversation, mediation, binding arbitration, and that litigation will not be used, and maintenance legal surveys, like the surveys I just described to you. So the prospective tenant's first impression might be, gee, why is there so much specific contractual relationship definition in the lease between the apartment manager and the tenants? And so here's our explanation for that. We take our responsibility to serve you with the apartment maintenance and apartment service very seriously, and we want to get it right, and have a record that we got it right, or be informed that we did not get it right, and fix whatever is outstanding in a timely manner. In addition, we know the apartment is safer for you, the tenants, if the appliance, heating equipment, and other items are maintained well and responded to timely. Furthermore, in order for us to offer this apartment to service to you at a reasonable rental rate cost, including paying the taxes necessary, insurance, heating costs, water costs, sewer costs, and mortgage costs related to the apartment, we have to define and control maintenance costs to the actual costs compared to the actual maintenance cost and additional related costs to an event that are not maintenance costs, such as legal or contest fees. We feel that most tenants like the apartment repair service and apartment maintenance this way because it may be considered that the apartment service is responded to in a timely way, allows the tenant to express themselves after the service has been completed, and allows issues to be closed and completed in a timely manner, so there's no open-ended distraction to the tenants to do their work or school schedule. We hope you appreciate and participate in the apartment manager to tenant apartment service and repair relationship. We will review and read some of the parts of the lease related to legal, service, and surveys. So when you get the lease, one of the parts is agreement of how parties will settle conflicts, mediation versus arbitration versus litigation. Conversation and dialogue. Conversation and dialogue is an informal way for parties to express and make requests and assertions to each other in the relationship, such as text, email, and telephone. Parties are encouraged to express themselves and make requests upon the other party to resolve conflicts. This means that if you need repair, you got to tell us. You got to express that, and you're encouraged to do that. Mediation is an informal and confidential way for parties to resolve their disputes with the help of a neutral third-party mediator who is trained to help people to discuss their differences. The mediator does not decide who is right or wrong, nor does he or she make a decision. Instead, the mediator helps the parties work out their own solutions to their problems. And arbitration. Arbitration is a private method of dispute resolution in which parties select the individual or individual arbitrators who will decide the matters at issue following the process agreed upon by both parties. Arbitration is generally faster, less expensive, and more confidential than litigation. Compared to litigation, however, parties in arbitration have fewer options to appeal an arbitration award if they disagree with it. There are a number of private organizations that provide arbitration services, including the American Arbitration Association. Litigation. Litigation refers to the use of state or federal, depending on the claims asserted, the amount at issue, and where the parties reside. Court processes to resolve this dispute according to the rules in place in that jurisdiction. The court procedures governing litigations are highly formalized, may be very costly. Cases in litigation are heard by a judge and jury. Disputes between the parties. Conversation and dialogue, mediation, and binding arbitration between the parties as an alternative to litigation. Parties agree to and this is between the tenants and the apartment manager. And parties agree to conversation and dialogue by text, email, and phone as a first step to trying to resolve their disputes before mediation and before binding arbitration. Parties agree to mediation and binding arbitration as an alternative to litigation in case of disputes. Case of disputes, any and all disputes that cannot be settled through conversation and dialogue, both parties agree to use mediation and then binding arbitration instead of as an alternative to costly court litigation system. So conversation and dialogue will be used first, then mediation will be used second, then binding arbitration will be used third, and litigation will not be used. And then the lease goes on to specify specifics about this. If we have a dispute that you're not happy with, there are these steps that you follow, which we can both do in a cost-effective manner to settle the issue compared to involving expensive litigations. This is very important to us, and we would not be able to offer the apartment service to you at the rent that we do without these type of things in place. Some of this talks about if you need a remedy, a specific defined remedy for an issue. For instance, if you have a plumbing dispute and you must request that we make the plumbing repair, but let's say we didn't make it. Well, the lease defines that what you are due is a specific remedy, such as hiring your own plumber and fixing the repair, and then let's say the bill was $350, you would deduct that from the rent. This is compared to filing litigation to solve the matter. And you do this because we would respond to that repair. But if we didn't, you could say, well, this is the damage I suffered. It was this bill, and you would have to show us a copy of that bill, and this is the remedy. And we would agree to that because you have proven that this repair was necessary. It was made by a third party, and we would consider the matter settled. So we hope you think that this maintenance relationship and legal relationship and survey relationship are fair and equitable, and that it allows each party, the tenants and the apartment manager, to do their work in a professional manner and get things resolved in a timely manner so we can not have outstanding issues. Thank you.